Good afternoon, and thank you for inviting me. My name is Polly Morgan. I'm an Associate Professor of Law and a solicitor. I refer to myself as a radical feminist, meaning that I believe that the structures of society operate to oppress women, and that the solution lies in challenging those structures. I do not, however, believe that the existence of a usable process enabling people to change their legal gender presents risk to women's voices or to the safety of our spaces. The Gender Recognition Act 2004 enables an adult to obtain a Gender Recognition Certificate, or GRC, and thereafter to be treated as the required gender for almost all purposes, including on any form that asks for their sex. In this way, the Act muddles sex, the physiology, with gender, the social construct, but then the physiology sometimes muddles itself up, as we shall see. The legal process requires a person to live full-time in their required gender for at least 2 years, irrespective of whether it is safe for them to do so, and to evidence this. Humiliatingly explicit medical and psychiatric reports are needed. The waiting list from referral to first appointment at a gender clinic is between 18 and 36 months. The wait for hormones and surgery is longer, but surgery is not necessary. The person must, however, have a diagnosis of gender dysphoria from a registered medical practitioner or psychiatrist specialising in this area, of which there are only a few. They must also sign an affidavit confirming their intention to live in their required gender for the rest of their life, and they can be sent to prison for giving a false statement. If they are married, they must have their spouse's consent or dissolve the marriage. They must pay a fee. All of the evidence goes to a panel run by the court service, which has the power to accept or reject the application. If granted, the person is entitled to a new birth certificate. While 95% of applications are granted, just 300 people apply each year. Nearly half of those who identify as trans feel they do not meet the requirements. Put simply, having dysphoria means a feeling of being born in the wrong body. Not all people who wish to change their legal gender have dysphoria. Some have disorders of sex development, for example. Their chromosomes may be XXY or one of another 20 or so viable DNA combinations affecting, visibly or invisibly, the ascription of sex. Sometimes genitalia can conflict with the unseen evidence of their internal organs. Sometimes it can be ambiguous. For many years, surgery was performed on babies in order to correct this, usually by making the baby look female, as this is surgically easier. That decision can be wrong in hindsight and morally, and the route available to such people is the GRA, even though they are not dysphoric. One of the reform possibilities is to remove the dysphoria requirement. One of the key areas of concern is whether people will be able to self-ID so that they can enter women's spaces for harmful purposes, and that this will happen like a legislative runaway train without any exceptions or safeguards. When we refer to self-ID, what we are discussing is the removal of the requirements for medical and psychiatric reports, as has happened in a number of countries. While the government here has consulted on changing the Act, it has not come up with any proposals. If we did move to a self-ID system, that could still be coupled with safeguards, such as a period of living the acquired gender. In Ireland, for example, certificates can be revoked, and there are many exceptions where people can be treated differently on the basis of gender, including gender that they've acquired. In this jurisdiction, the Equality Act 2010 prohibits discrimination, that is, less favourable treatment, harassment or victimisation on the basis of a person's protected characteristics, which include sex, defined as being male or female, and gender reassignment. Gender reassignment protects a person who is proposing to undergo, is undergoing, or has undergone a process or part of one for the purpose of reassigning a person's sex. It also protects perceptions that a person is gender reassigned. It therefore covers people anywhere on the transition route, including pre-medical, those with or without a gender recognition certificate, and natal women who people mistake for being trans. There are multiple areas where the Act says that you can discriminate. It is perfectly legal to provide single-sex services and exclude those with the characteristics of gender reassignment, as long as that is a proportional way of achieving a legitimate aim, such as that people are less likely to access services if certain people are present. Domestic violence refuges and rape crisis centres are able to offer single-sex services or make them accessible only to neutral women. It's also possible to lawfully discriminate in competitive sports or activities where there would be a sex-based advantage or for safety. You could exclude trans women from women's prisons whether or not they have a gender recognition certificate. Single-sex accommodation is allowed. Women's organisations can continue to limit entry to the single characteristic of being a woman. Some argue that because the Gender Recognition Act recognises trans women with a certificate as women, there's no scope to exclude them from such groups on the basis of gender reassignment. That's an argument made by people who don't understand how laws react with one another, or the principles of statutory interpretation, and prefer to believe that the law created a closed loop that would render it unworkable. There's a detailed explanation by Professor Sharp in the Modern Law Review, but my view is that people with the protected characteristic of gender reassignment can be excluded whether or not they have a certificate in all of the situations above and some more I've not mentioned. Making it easier to get a GRC does not change this, but you must ensure that in doing so you have a legitimate aim and are not unnecessarily excluding people altogether when a lesser measure would meet the same aim. That's not me saying, look, it's okay, we can continue to discriminate. That's not my view. Trans people live with these restrictions and suffer an outsider status backed by the full force of law. I do not believe that oppression of a very vulnerable minority is a solution to the systemic issues faced by women. Trans and natal women share a common vulnerability to male violence. Maybe they just want to go to the toilet, play tennis, or obtain medical care. And studies that looked at the safety of single-sex spaces have found that self-ID laws have no effect on the level of criminality there. But if your concerns relate to these things, then the legal protections are already in existence, and the government has confirmed they'll stay. And don't forget, in addition to being able to exclude someone on the basis of a legitimate aim, the law also does not prevent you from banning someone because of a risk assessment, or for being unpleasant, or badly behaved, or for drowning out others' voices. It merely restricts you from excluding a person because of who they are, not because of what they've done, without a legitimate reason. And I submit that's how civilised and equitable societies work.